people's
That's
permits.
against the law.
Can
Sorry.
Can I finish? No, I didn't interrupt you.
I'm sorry.
Okay?
Sorry.
didn't.
I apologize.
So I felt very strongly that a written open records request was the proper way. There's been people who have asked me for permits for the event a few weeks ago where there was 30 to 40,000 people here at the Capitol. I did not make that permit available. I felt again, open records. Request it, we will deliver it. I'm not going to go out and start handing out people's information on these permits. I think I have that right. So that's what happened there, and since that time I've made 1 or 2 written requests that will be filled and will be taken care of in a very short period of time. And I apologize to you, sir, for not getting back to you and telling you that I think I did get back and tell you we need a written request. That's how I'm going to operate. I'm just not going to I'm telling you right now, there is a permit signed by me authorizing that event to happen on Friday, December 2nd.
I have one more quick question. Were you notified 72 hours in advance of the governor switching from noon to 8:15?
Yes, sir. I was actually notified of the event probably 3 to 4 weeks prior to the event.
That was switching.
No, I'm sorry. Of the event taking place that day.
But how about the switching of the times?
I was notified definitely well in advance of the 72 hours.
With a written permit?
With
Filling out this.
With an amended permit.
let me just tell you on that permit. Again, I feel I have the authority to work with each and every one of you. And there's some people here right here in the crowd today can tell you who have came in to see me at the last minute and needed to make a change in their permit and say, hey, look, and we have this, and this, and I've honored it. So this is nothing new. There's no secrets here to hide. I have worked with everyone. If there's something that needs to be changed, if you tell me we need more electricity, I go to Sue. Sue makes sure that happens, and that can be in the 9th hour, okay? And we try to make it happen for you.
No, that's true.
Who's going to answer his first question? Why now?
First question, why
I think,
now?
and we did discuss that at the top. I'm sorry that you missed it.
I missed it. But
No.
if you
And
would.
there's really two reasons for it. First off is that we didn't believe that we had one document that made it very easy for people to understand what the process was going to be. And so we've developed that based on what was in the administrative code, in chapter 2 of the administrative code. So it lays out very clearly what the expectations are for everybody so that there aren't surprises in that. The second part of it, as we discussed, look, it's been a very precedent-setting time for the last 10 months or so. And we have had a number of legal questions and some court cases over how we operate within that particular realm of permits. And we felt it was important at this time, particularly with the status of one suit, in order to put that process and that policy out at this time. So probably driven by both of those things.
Does it have anything to do with the handbook coming out shortly or soon? And do you have a date when that will be coming out?
I don't know on that.
Is it published?
Personally, I don't know.
My question goes directly to your last statement.
Okay.
So you're basing these new requirements upon Chapter 2, and you believe you have the authority to enforce. And by the way, my name is Leslie, and I'm a citizen of Madison. For the situations where there's already settled law that we do not need a permit inside the Capitol and on the grounds of the Capitol, in fact, we don't even need a permit to amplify using our own means outside the Capitol. This is all settled law. Are you suggesting that that you're going to violate the law by requiring people to get a permit when it's not required because it's already settled law? Or are you suggesting that people apply for the permit, then have the permit denied, and then we take this all and work it out in the courts at the taxpayer's expense? And that's really my question. Since there are so many things that are already settled law, and I have the lawsuits in my hand, and I've already consulted with the attorney. I understand that you're not an attorney, but this is settled law. And so is the DOA suggesting that they are going to violate settled law in order to enforce an illegal permit process and then require us to sue the Department of Administration yet again, which is a taxpayer expense for the DOA to then defend when it's already settled case law in the books?
I don't want to comment on what is or is not settled law. And
Well,
what
I have it right here.
And again,
It's
I'm not
public
gonna-
knowledge.
I'm not going to be able to debate that with you at this time. I think that's a matter for the attorneys to debate, and for anybody, whether it's the state of Wisconsin, whether it's an individual. If they choose to go through the court system, that's a right that we all have.
If I can I say something as well? I think, maybe some of you didn't hear when we first got it, Sue has stated she gets over 400 to 500 permits a year. I can tell you right now, this is not new. I can tell you some of our largest rallies that we've had here this year has been on a permit, and I've approved them.
It's not required.
But regardless, I'm not here to argue that point. I just want to make sure we understand, this is not new. These permits have been here. Chapter 2 has been here. We've operated. Now, I can tell you, and I'm not going to put anyone on the spot, but there's people right here in this room who come to my office and say, well, why don't you guys tell us what we need to do ahead of time? You've said that to me on a number of times, some of you. And they say, well, look at Chapter 2. We don't understand Chapter 2. I think this is a little bit clearer, I really truly do, than Chapter 2. But here's the key I want you to remember. This is not new. Permits have been going, I've been signing permits, I've been here over 3 years signing permits. And like I say, some of our largest, when we had 100...
Including definitions of 4 or more people and spontaneous events and fees.
Because nobody's answered my question. Excuse me, Brian, I still haven't answered my question.
Here's what I'm doing, Brian. I
That's
don't
fine.
interrupt
Answer
her,
her
okay,
question.
please. Okay, I just want to say, I just want to be real clear about the permits. It's not, they're not new. They've been here.
The fees are new.
The fees are new.
Okay, I can tell
That
you.
wasn't my question.
I'm gonna say one more thing. I know that, but I've been hearing the entire crowd. I think this will help us understand, but I want to say something about the fees. There has not been a lot of charging in the past for these events. There has not.
There's been none.
Okay? Okay? We have to look at every situation and try to improve every situation we're having here. Okay? But I want to be clear. The permits are not new. Please understand that. They're not new.
Chief
But
Tubbs, I just have a
still like
clarification
to answer
regarding
my question.
Craig's question. I would like to clarify that the public records law does not allow you to ignore a request that is not in writing. All it states is if a request is in writing, that you're required to respond in writing. It does not mean that you can ignore a spoken public record request. Craig made a legitimate public record request to see that, and you ignored that. Your duty is to respond as soon as practicable and without delay. And that means that if you have the record there right in your office and he's right there, you have the duty to provide that to him. That's part of your job.
I have 10 days. I have 10 days to respond.
That's the maximum.
Okay,
No, as
okay.
soon as practicable and
Okay.
without delay does not mean 10 days if that record is sitting right there in your
I'm not,
office.
okay, I don't want to argue about it. Okay. I didn't honor his request, I did. I've admitted to that. But I've told you what I'm going to do, what I will do, and what I'm planning to do here. And I can tell you right now that they will get a copy and be able to see that request that they would like to see.
You're saying that you're going to ignore public record requests that are not written? Is that what you are saying?
Here's what-
Because that is contrary to the law.
Okay, and again, I'm not an attorney, I'm not going to get into the law, I'm not the expert there. All I can tell you, I refer this to our legal
Some
team.
attorneys here.
Our legal team is going to respond, and that document will get out, okay? He will get a copy of it. If he chooses not to send it, I don't know where to send it to you, unless I see him here. And here's the other problem I get on these requests. I get one request verbally, and then when we send it out, then I get repeated phone calls and questions. Why didn't you answer this? It's clearer to send us a written documentation on what you want in these sort of clarifications. That's what we'd like to have. Okay?
I want to get back and answer your question. From our legal staff, they believe that what we have in this policy is legal and defendable.
It's settled law.
Certainly that's your opinion.
I'd like Representative Taylor, who's an attorney, to speak to that.
We have it there.
Well, I'm happy to speak to it. Yeah, thank you. I'm Chris Taylor. Thanks for being here. And I represent the 48th Assembly District. And I have to say, I've heard more from constituents about this policy coming out than any other issue since I've been here. So there is a lot of concern. There's a lot of uncertainty about what it means. And I think the piece that really is new is permitting for 4 more people. I mean, I have the old policy. I've read through it. I've read through the new policy. And you never had anything like that before. before, and I do have a lot of concerns that we have, you know, and Chief Tubbs, you know this, we have a lot of lobbying.
I'm sorry, didn't hear that.
Well, I mean, you know this from being in the building, that we have a lot of people coming in for organized events like lobby days and whatnot that have never needed a permit. And I've been a part of a lot of those activities, and we have never needed a permit to come in and do lobbying here or advocacy on any issue before more people. And I have a lot of concerns about how is that being enforced when you have one staff person, and that seems like it's going to be a lot more work for you. And I do have deep concerns that this does violate constitutional law. And there's a lot of case law, and particularly political speech, which is the most protected speech that there is. And we have a lot of case law on how sacred that type of speech is. So I think one issue, a new issue, is permitting for people. I think that I'm just not sure how you're going to implement something like that. But my second concern is this very broad provision that, and there's more concerns, but these are the two main concerns, that says that someone who promotes or participates in an event can be held jointly and severally liable for law enforcement fees. You know, and does that mean that someone who hands out a flyer is participating and could be jointly and severally liable for fees? And how do you determine what the fees are and what's the process for that? But that also really seems to me like we're imposing a fee on people exercising their constitutional rights. If we're going to say you have to pay to participate in a large gathering, then we are saying in order to express yourself politically that you're going to have to pay to do that. And I don't know how you all are going to get around some really well-settled constitutional provisions with that. I don't know. You know, I've tried to find out if there's any other state that requires anything like this in the country, and I don't know that there is, that requires people who come to the Capitol, even if you have a permit, to pay for law enforcement costs. I mean, that would be like saying, well, if you call the police because your house is being, you know, robbed or burgled, you're going to have to pay the police. But this is even more precious because these are constitutionally protected rights. So it seems like that is a huge, huge legal obstacle for you all. And I'm not sure how you're getting around that.
Now, let me respond. We talked about it a little bit up front,
Okay.
but we're not going to resolve constitutional issues here. Obviously,
Right.
that's not the point. And if folks have concerns about that, we talked about that, and they want to take that to the level.
Physically see in court.
They absolutely should. We want to make this as practical as we can. Our legal team believes when they put the policy together that we have both the authority and the responsibility to do the things that we have in the policy. Obviously, that can be challenged. I understand that. I can't resolve that.
You don't need lawyers to understand plain English. Shall not be abridged is
Well,
clear.
let me just ask, just practically, how do you intend to implement something like, you know, holding people jointly and severally liable if they participate or promote a rally or an event? I mean, how is that going to work practically? Because one obligation that you do have is to give people notice on what behavior you are prescribing. And that is very well settled. Is the government, if you're going to say you can't do something or you're going to be held liable for something, people deserve to know what is it that they're going to be held liable for and what kind of conduct is it that's going to make them be held liable. And when you use words like participate or promote, those are very, very broad concepts. So just, you know, how are you going to implement this? Because those are the questions that I'm getting in my office. And I don't have any answers to that. But just on that point, I mean, I just...
And I think with the permitting process, as we mentioned earlier on, that really begins the discussion. And for our legal team, they're going to have to review, okay, if we've got a particular issue, are we on solid ground? We believe we are, but then getting into the specifics, how we discuss that with an individual applicant will be an ongoing conversation with folks.
But the public has a right to know this right now. I mean, you can put these policies out there, and the public has a right to know what you mean by these policies and what types of steps are you going to take. So, you know, particularly when you're talking about limiting political speech, I mean, I just think that if you're going to enforce policies that you can't tell us how you're going to enforce, or you can't tell us the details of those, you know, that's not fair to any of the people here. It's certainly not fair to the public. They deserve to know how are they going to be able to participate politically in our legislature. So, you know, I would urge you all, before you enforce this, when we have a right to know what kind of behavior are you prescribing. And certainly if you're going to hold people liable financially, people have the right to know what is that going to mean.